All right, counsel, you've each received a photocopy of the court's ruling regarding requests for discovery sanctions. My apologies to counsel for the court's failure to fax you a copy earlier than today. I experienced a complete breakdown of my fax program at home. I attempted to fax this to all parties yesterday and was apparently obviously not able to do so. If the parties wish, I'll give them leave to review the ruling, and I would, court's ruling asks for input from both parties regarding opening statements and the jury instruction.
Yes, I've read it. I've read the procedure.
All right. Ms. Clark?
Would like the opportunity to review it more carefully, Your Honor. There are a number of items that I'd like to take up with the court and have an opportunity to confer with co-counsel concerning the court's ruling.
All right. How much time do you think you need?
I would like at least until 1:30 to address these matters.
Well, Ms. Clark, let me tell you what I think the two issues are that we need to resolve this morning. You've seen the court's ruling and the court's proposed jury instruction to the jury to disregard opening statement comments regarding the witnesses that are listed on page 4. This is significantly different than the instruction that you requested. You requested an instruction directing the jury to disregard the comments of counsel. I think that is overbroad. And I think the only remedy is to mention or to ask the jury to disregard defense counsel's reference to these particular witnesses, or if there are any others you feel that have been mentioned in the record that whose mention was inappropriate.
I don't appreciate that part yet.
All right. Do you agree with the list that the court has taken from the record?
That's the only, with respect to this area, I was reviewing the transcript last night, and I thought that there were more references to other witnesses.
Well, that's why I asked for a draft. I asked both sides for a proposed instruction because I was seeking particularity with regards to the court's instruction to the jury. This is the list that I have here on page 4 as a result of my going through the record line by line, noting where these persons had been mentioned and then comparing with the witness lists that have previously been disclosed.
Your Honor, I'd like to hear regarding this.
Oh, certainly, Mr. Clark. Sure.
There are certain notable witnesses who are not mentioned that we specifically delineated to the court when we were last in session. Expert witnesses promised by the defense, although not by name, who have never even been disclosed by name to the prosecution, such as an expert in tire tracks, an expert in shoe prints, an expert on finger cuts, an expert on rheumatoid arthritis. None of these have even been named to us. And then again, the statements made by counsel concerning alleged conclusions drawn by experts Dr. Bodden and Dr. Lee. We have no reports. We have no idea what counsel intends to present in the way of their testimony, having had no discovery. So there are many more that I would add to this list, and that the court is aware were not disclosed to the prosecution in any way, shape, or form.
All right. Well, you'll notice that the court's order includes those specific persons, and I make reference to the transcript where certain expert testimony is mentioned, and it includes the ones that you've just listed now. And I think that the requirement at this point is that they be disclosed, since obviously there has been indicated an intention to call those persons as witnesses.
Where does the court indicate to the jury that those experts have been?
No, we're not there yet.
Oh.
Flip back to page 2, where we start with the section on expert witnesses. All right, first full paragraph after the quotation from the code section. There's an order from the court directing disclosure of these persons' reports, et cetera, and in addition, other experts mentioned by defense counsel at these particular places in the transcript, which include the ones that you've just mentioned.
Is this part of what the court proposes we say to the jury?
No, because I think what I need to do is first determine who these people are, because they may be persons already disclosed to you. But my concern here is also the reports.
Then we have no.
If the people were not mentioned by name to the jury in opening statement, those witnesses, the people are not aware of who these experts might be, even
But
by
Ms.
name.
Clark, if you read the first sentence, it says the defense is therefore ordered to immediately disclose, blah, 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 and the identities of these persons.
I'm aware of that, Your Honor, and all
All
I'm
right,
saying
so I
is that-
assume that that's going to happen today. Now, after you've had the opportunity to find out who those people are, then you can make your judgment as to whether or not they should be included in the court's instruction to the jury.
Then I'm unable at this time to indicate to the court what the people's position with respect to this ruling, because there's information we still don't have.
Well, it's a ruling. After you've had the opportunity to look that over, I'm going to proceed today. My inclination is to instruct the jury, as I've indicated today, and to move on with the case. And if it comes to light that there's something else, I can always re-instruct the jury as to other particulars.
But there's already an indication there are other witnesses that have not been disclosed to us by virtue of counsel's opening statement concerning those experts.
We don't know that yet.
I'm-
I have the suspicion that the tire track person is probably Dr. Lee.
A suspicion is certainly nothing that we can
Your
call
Honor, so
discovery.
suspicion, it's Dr. Henry.
Well, thank you very much. I finally hear this this morning. That people are entitled to discovery, Your Honor, not an assumption and not a suspicion.
we give a document.
We haven't been
Hold on.
told anything.
Hold
We
on.
haven't seen a report.
All right, I agree. And Ms. Clark, that's why I've ordered its immediate disclosure, which means today.
And I appreciate it, Your Honor. I really do. But I'm asking for the court to inform the jury that we were not informed of any of that either. That should have been disclosed to us as well, not just these witnesses, but the experts and what they were going to testify to. Why did we find out only in opening statement that Mr. Cochran intends to call these expert witnesses to testify to various things of which we had no knowledge? The code requires them to do so. Those experts that he mentioned in his opening statement, for which we had no discovery, and only now, based on the court's stated suspicion, do we hear that that's who is going to testify to what he represented to the jury for the first time ever when we heard it. That's a blatant violation as well. We were entitled to know about that.
Hold on.
just as
Mr.
we-
Cochran, you'll have the opportunity to respond.
Thank you.
We were entitled to know about those witnesses, just as we were entitled to know about the witnesses listed by the court in this order. That's why I'm asking for the court to include them in the order. Why would they be any different?
All right, let me ask you another question. What is your position on your request to reopen at this time?
The people strenuously urge the court to allow us to reopen. I will cite to the court the civil case that I brought down to court the other day, unless the court already has it through Lexis, but it does authorize the reopening of opening statement. I'd like for the court to see that, and we would like to reopen. The court has requested a proffer as to what we would address in the opening
Yes.
statement, and we will, until Mr. Cochran completes the opening statement, we're not going to know the entirety of it, because although it's been represented to us, we have full and complete discovery, we obviously do not. And I don't know what other surprises are going to be forthcoming from Mr. Cochran, so I can't give a complete proffer as to what we would state at this time.
Well, as to the individuals who are listed in the court's proposed instruction, as to those listed individuals, what is your proffer?
Well, we don't have a statement yet from Michelle. We don't have a statement from Mark Partridge. We don't have a statement from Howard Weitzman. We don't have a statement from Skip Taft. We don't have a statement from Christian Reichart. We still don't have discovery of that. And in order to know exactly what I'm going to say in response, I need to have a statement.
My recollection is that is a list of people whose statements were belatedly given to you and/or... Yes, those statements were given to you, albeit at the close of business after the first day of opening statements by the defense.
No, Your Honor, we have never received a statement for Michelle. Mark Partridge, I believe there's a one-paragraph representation that he spoke to defense counsel, but no particulars as to what he said. Howard Weitzman, we had no statement. Skip Taft, no statement. Christian Reichart, no statement. There's only one witness here for which we really have a statement, that's Marianne Gerges. And we are putting together our proffer as to her at this time. I believe that Mr. Darden will be bringing it down with him.
May I respond to this situation?
Well, hold on just a minute, Mr. Cochran. I just wanted to settle where we are at this point. All right, Mr. Cochran.
Yes, Your Honor.
Good morning, sir.
Good morning, Your Honor. I just got Your Honor's order this morning, a proposed order, and we've had a chance to review it. I'd like to, first of all, turn our attention to the list of witnesses that the court proposes to tell the jury about in the jury instructions, which I think is the heart of Your Honor's proposed order, obviously. With regard to Marianne Gertjes, Mr. Douglas has indicated that, and our position is and will always be and absolutely is, that when I read the name Marianne Gertjes, I believed that statement had been turned over. It, in fact, hadn't, and we indicated that. With regard to Michelle Abduram, there is no statement. With regard to Mark Partridge, the prosecution, Your Honor, had in fact been given a portion of his statement. In fact, in a letter that he wrote after a memo where he's a lawyer, as the court is aware, and we returned back to Chicago, if I recall, and I'll try to find this, Mr. Partridge wrote a letter detailing his observations of Mr. Simpson and sent a copy to the prosecution and to the defense. Mr. Douglas turned over another 2 pages, I think, afterwards. They'd already been notified of Mr. Partridge and had an earlier statement, and I believe they also had his lengthy memo about what had taken place. With regard to Howard Weitzman, Skip Taft, there are no statements. These are both lawyers, and we try to explain that to the court. There are no statements. It's no subterfuge. If the court is aware of the relationship we would have with Skip Taft, a business lawyer that we talk to on a daily basis, there's no report.
Well, the problem, Mr. Cochran, is that neither of these persons appear on your witness list.
But and I appreciate that, but I'm saying there is no report regarding those two. With regard to Christian Reichard,
But the fact that they were not placed on the witness list, there's no notification to the other side that they're going to be witnesses, that's the problem.
all right, and I understand that I've indicated to the court that's through inadvertence, and I understand Your Honor's sanction on that. With regard to Christian Reichard, they have interviewed Christian Reichard at length. He's on the list, interviewed him at length with Dominic Rubalcava, the lawyer. There's a transcript to that effect, I believe. And we have no statement, we have no report from Christian Reichard. So I guess what I'm asking the court with regard to Reichard, I don't understand where the prejudice is. We have no report. They know about him. He's Faye Resnick's former fiance. You heard what Mr. Darden said. You know, it's very interesting, Your Honor, how Mr. Darden could immediately make some statement maligning Christian Reichard when he knows everything about him. Or for instance, with regard to Marianne Gertjes, when they heard the name, it seems as though they'd already known about her. And the court will recall that with regard to Marianne Gertjes, this is not to obviate whatever you feel is proper. I'm prepared to go forward and argue. Marianne Gertjes had tried to contact the district attorney's office. The court should read that statement. She not only talked to Patty Fairbanks in the DA's office, she puts in the statement, if I recall, the phone number in the district attorney's office that she called.
Mr. Cochran, though, that's dancing around the issue. The issue is, was this person named as a witness by the defense?
No, she was not.
Were the statements in your possession turned over prior to trial? The answer to that question
She
is
was
no.
named. She was named, I believe, but the statement was not turned over, as I've indicated to the court. But
That's
I wanted
a violation of the discovery rule.
Okay, and I appreciate that, Your Honor, but I thought the court should have all the facts. And I think what it does, it goes to the state of mind, our state of mind. Your Honor, and I'd just like to say this again. No way in the world, why in the world would we want to withhold witnesses from them that you could possibly preclude down the road? I'm not going to do anything to damage Mr. Simpson. And the effort of this is a massive volume of work, is not an excuse. We want to get this case underway. We're not going to do anything to harm that. We want to try the case. We're the ones who've not waived time and want to get it forward. We understand we have to all abide by the rules, and we accept that. The other thing I think that the court should listen to is that this violation of, in the jury instruction, proposed jury instruction, the court proposes this was violation of the law and the cause of the 2-day delay. Well, that's not completely correct, because as you indicate later, the part of the cause of the delay was the illness of D.A. William Hodgman. So I think the court needs to modify that in some way so it more accurately reflects the facts. If that was the only cause, we perhaps could have argued on Friday or whatever. So I think that I would ask the court to consider that. With regard to the experts, we will comply wherever possible, Your Honor. We do not have reports yet, because much of the reason we don't have reports, Your Honor, is because our experts have not been able to actually examine the evidence. We're making a motion to that effect, to be able to examine this evidence in their lab. They can then make the report. We know generally from their observations what they're going to say. And for counsel to say that they didn't know about Drs. Batten and Drs. Lee, and Dr. Lee and Dr. Wolf were out here the week of June 12th, Your Honor, as the court is aware. The other thing is, as the court correctly points out, in this reopening of the opening statement, it is illogical at best, and I think it's going to be confusing at worst, to allow them to reopen to talk about Marianne Gertjes. From that standpoint, I think that if you admonish the jury to disregard it, then they get up and then talk about her. That doesn't make any sense, Your Honor. Then do I get a chance to respond to what they have to say? Your Honor, what's happened in this courtroom is they have continually maligned witnesses, and that is an intimidating effect, and that is wrong. And so while we're talking about the defense, let's talk about them. Over this weekend, every one of these witnesses who were maligned by Mr. Darden now have lawyers. Marianne Gertjes, Christian Reichardt, Ron Fishman, and Rosa Lopez.
Your Honor, I object to this. None of this
Hold on,
is
Ms. Clark.
responsive.
Ms. Clark, please.
None of this is responsive to the court's
I'm
question.
going to instruct counsel not to interrupt other counsel's statement. This court is more than patient. I allow each side to completely say what it is they want to say. I'm not going to tolerate any more interruptions by counsel from either side. That's a warning to all counsel. Next violation will be dealt with by sanctions,
Thank you.
including contempt.
May I proceed?
Please.
Thank you. Your Honor, what I was trying to say was that I think that it's totally improper to do those things because it has an effect on these witnesses, and I think it's totally unfair. Now, what the court's going to see is in the coming weeks, these lawyers will all be addressing this issue, and it has a pronounced effect when a district attorney stands up and says that and does that in open court. And I think that is germane what we're talking about and to procedures, Your Honor. So I would just like an opportunity, if the court would allow us, to respond to the people's request for this reopening. As I said, I think that's totally being improper.
Well, Mr.
proceeding.
Carpin, what I anticipate doing is after I hear the prosecution's proffer as to what it is they would go into and how it is that they would approach it, then I'll allow you to respond to that to see if it's appropriate.
Thank you, Your Honor, because I think that what we've seen so far, again, is trial in the media. What we saw in court here, to have a witness who's never been before this court, I presume branded as a certified pathological liar, Your Honor, that's outrageous. And if not, would not be done except under the aegis of some kind of qualified immunity here in court. And I think that's unfair to that witness, and obviously it had a great effect upon her. And what kind of message does that send out to other witnesses, Your Honor? Furthermore, all the things that were introduced, Your Honor, the things that were introduced would probably not even be admissible from a standpoint of attacking this lady's credibility. She has some civil lawsuits. How is that relevant as to whether or not on June 12th, 1994, at about 10:45 in the evening, she saw 4 men running from the vicinity of 875 South Bundy? That's going to be really the issue, Your Honor, isn't it?
Absolutely.
That's the issue, and it seems to me that the other things that happen should not be allowed to happen again, because I'm just saying to the court that this is having a pronounced effect, and I know that because I'm being contacted by these people.
All right. Thank you, Mr. Carpin.
Thank you, Your Honor. I should say one other thing. At the bottom of page 1, I think it was clear as we'd indicated to the court. The other witnesses that were turned over, because the court had ordered Mr. Douglas to make that determination, and we should make it clear that he did exactly as you had asked, and make it clear also that this has not been his responsibility prior to January 2nd of 1995.
Well, I think the record speaks for itself.
All right.
Mr. Douglas did indicate that was his responsibility as of the beginning of the year.
Yes, and he took it over. And of that list, of the total list that we've heard so much about, Your Honor, and we dispute Mark Partridge because we think they did know him and had a statement from him, the only 2 people that basically mentioned in the opening statement were Marianne Gertjes and Michelle Abdram. And apparently there is no report that we have on the shelf. And I will make sure And the other thing that also comes to mind, Mr. Douglas reminds me, is the court will recall that in one of his diatribes, Mr. Darden stood up and said, if Ron Fishman tells the truth, he'll say that O.J. Simpson made a statement about getting somebody. Now, Your Honor, we've never seen any report like that. We've never seen any such statement. And so when he makes those kind of statements, or when immediately he knows about Marianne Gertjes, in another statement he says, if you recall, if Mr. Cochran had asked me, I would have told him about this witness or these witnesses. How does he know those things, Your Honor, immediately if he didn't know about these witnesses? So I think the court, in being even-handed, which you are, would want to inquire about that.
Well, I've already sanctioned the prosecution severely for their transgressions in the discovery process, and this sanctioned proceeding process, I suspect, will continue throughout the trial.
I certainly hope not after today, Your Honor. will not be proceeding. I hope it won't be necessary. But I understand that. But I'm saying, how would he then be in a position to give me advice about witnesses if he had known, or to have a statement from Ron Fishman if he didn't know about Ron Fishman? I don't understand that, and I don't think that makes sense. So I would ask the court to inquire about that. To conclude my point, though, of the witnesses that you'd ask Mr. Douglas to proffer for the court, we did that. As Mr. Douglas has indicated, many of these witnesses were out of an abundance of precaution, will probably never be called. But secondly, they have a right to know about it, and we've done that. But almost none of those witnesses were mentioned in the opening statement, with the exception of Gerches and Michelle Abduran, as I said, referring to the list at the bottom of page 1, Your Honor.
Well, you did mention Gerches, Abduran, Partridge, Weitzman, Taft, and Reichart in your opening comments.
Right. I was referring to the list at the bottom of page 1, and I did, in fact, mention the others. And as I said, there are no reports, but I did, in fact, mention them. But I think, again, Your Honor, in the spirit of the law, the prosecution, Your Honor, knows about Howard Weitzman and Skip Taft because they were down there with Mr. Simpson at the time he gave his statement. Now, we don't have a statement, and it was an oversight, and they should have been put on the list. These are two lawyers. Now, you know, I mean, I don't think the court's going to shoot me over that. I mean, I think that he may want to.
Don't tempt me, Mr.
I don't think you're going to shoot me over that. And Kristen Reichart, Your Honor, they know about. They've interviewed him. They know that's Faye Resnick's boyfriend. And I think that, as I said, with Mark Partridge, they had a statement on him. So I think the court has listened to us. I'd like an opportunity to respond specifically when they're ready. But I'd like to proceed, Your Honor. Let me just close by saying the court can give these proposed sanctions, and you've done that for the prosecution. I mean, I think it should be clear they were sanctioned, and you did that, and now you impose sanction upon us. We will proceed with those. I think that you should make some adjustment in that in the order regarding the delay. I think it's not fair to say it was all the defense. But we're then ready to proceed, Your Honor, and I would like to be able to proceed this morning. Keep in mind, if you want to talk about sanctions, how unfair it is to Mr. O.J. Simpson. But number one, through no fault of his, I couldn't respond immediately when the prosecutors had finished on Tuesday. The court declared a recess. On Wednesday, I was able to start responding. Then we had all these objections from the prosecution. Then Mr. Hodgman gets sick. Then Thursday and Friday, we've been off. The court says, be ready at 9 o'clock. We come in, we get the order about 8:30. We're ready. Ready again. I've been ready for about now 10 days to give this opening statement. Now the prosecutor says, gee, Judge, we need now till 1:30. I mean, at some time, I should be allowed to complete the opening statement, Judge. And I think that that also has taken the form of a sanction. And I think it's a sanction that's not only upon the defense, but directly upon Mr. Simpson. I'd ask the court to allow us to go forward this morning.
All right. Thank you, Mr. Clark.
Thank you, Your Honor.
Ms. Clark. I think what I'm most interested in is hearing what your contemplation is of your proffer regarding a reopening of opening statement.
What do we contemplate?
Yeah.
We have amassed information on several of the witnesses mentioned by Mr. Cochran that allows us to understand precisely why he hid them the way he did. And we are going to prepare those remarks for the court. We've been assembling that information over the weekend, and now that we're finally in possession of the court's ruling, we will address what the court asks us to address, and we're going to have to put that together in a form that will allow me to succinctly state to the court what the points are that we intend to address with each witness. I would simply indicate that the statement taken from Marianne Gerches most recently reflects the fact that counsel alone was in possession of her statement, that she asked counsel to turn her statement over to the prosecution, and counsel for the defense never did. She indicates very specifically that she spoke to Mr. Hostetler, whom we knew to be one of the investigators for the defense, and she told him that she wanted them to turn the statement over to us. So even the witnesses asked to do that, and the defense willfully refused to do so.
Well, Ms. Clark, you're arguing an issue and ruling that the court has already made. I've already made a finding adverse to the defense. I've granted a large number of the sanctions that you've requested. I am going to instruct the jury that a transgression of the law of discovery has occurred and has been part of the cause of the delay.
I think that
So
you-
to argue the basis for the court's ruling at this point doesn't help me a lot. What I need to know is, assuming I am willing to allow you to reopen, since this is a highly unusual remedy that you asked for, and the fact that there's only one civil case that deals with that, I've never seen a case allowing reopening after a discovery sanction has been imposed.
when has the court
And
seen
I
an
looked.
abuse, but when has the court seen a
Well-
violation this severe?
You're arguing,
Okay. Well,
I've already ruled in your favor, Ms. Clark.
Okay.
You don't
I'm-
need to tell me how severe it is.
Okay.
You don't need to tell me what the basis is. I think the ruling speaks for itself,
It does. I'm simply...
especially given the nature of the court's finding as to intent and tactical advantage,
Mm-hmm.
which is as harsh a finding that the court can make under these circumstances. So my question to you is, if I grant your motion to reopen, what are you going to say to the jury?
And-
That's the bottom line.
All right, and I've asked leave of the court to...
And what I would anticipate you are going to say is that you're going to tell the ladies and gentlemen of our jury, had the prosecution known of these persons, we would have told you about them X, Y, and Z. And that's what we're going to prove. I think that's about the maximum parameter that I would entertain. And I stress the word entertain. All right, at this point, then, I would suggest that we proceed then with the conclusion of Mr. Cochran's opening remarks, and that after the lunch hour, you'll have the opportunity to come back and ask me to reopen, and I'll rule at that time based upon your proffer after I hear Mr. Cochran's objections. I
Let
would
me-
suggest that, so we can make good use of the court time since we have our jurors seated, ready, willing, able to go.
I would
You
like
want
to
to
address...
discuss that with Mr. Darden for a moment?
May I address the court further concerning the expert witnesses?
Certainly.
Mr. Cochran indicated just now that some of the experts have not even examined the evidence. And I find it incredible that any officer of the court could stand before a jury and represent what conclusions and findings have been made when the experts have not even conducted an examination. That assertion that they have not even examined the evidence is incredible to me. If that is the case, and he's made representations as to what their findings are, I think that there's a great deal of credibility lost with respect to those witnesses. Obviously, it's going to be a bootstrapped conclusion. Counsel, who is not an expert, can stand up and tell this jury before an examination of evidence is conducted what the result will be. I find that remarkable. And I think the jury should be informed of that fact.
Well,
I think they
Ms.
should be
Clark-
told, Your Honor.
Ms. Clark, that's an interesting point, but I don't know the full parameters of what it is we're talking about until the disclosures of expert witness lists have been accomplished as I ordered today. I can always re-instruct and re-admonish the jury at any time during the course of these proceedings. You can also bring up during the course of your closing argument that contradiction.
I'm aware of that, Your Honor, but that doesn't address the harm that's already been caused in that counsel has indicated to the jury certain experts exist who will testify to the following, and we had no knowledge and no prior discovery of any, not even their names. Only this morning, because the court indicated it had a suspicion about who that was, did we find out what that was. Now
Well,
he
it's not a
tells us...
suspicion, it's just a logical conclusion from what we already all know about the case.
Okay, but that does not comply with any discovery law that I'm
This is
aware
true.
of. All right. So counsel is indicating now that he's going to testify to tire tracks and to shoe prints that were found at Bundy. We have absolutely no report, no knowledge, and no information that any such testimony would be forthcoming. Those should be included in the discovery sanctions as well. With respect to Lenore Walker, I'm particularly surprised and dismayed at what counsel has represented to this court. Counsel represented to this court when last we were here that Lenore Walker was only contacted for the purpose of testifying in this matter in January, just a few days before the discovery hearings occurred. That's false. It was stated in the Los Angeles Times by Dr. Lenore Walker herself that she was retained by counsel in the summer of '94 and that she has spoken to the defendant for hours in preparation for her testimony. So the violation is even more flagrant with respect to her. At least that's according to what she said to the LA Times. So counsel is now continuing to perpetrate a fraud upon this court, is continuing to make misrepresentations concerning the nature of the witnesses that they have contacted and their involvement in the case. He is still withholding more information. There are witnesses whose names we still don't have, and obviously there are no reports. That's a flagrant violation of the law, and now it's compounded by counsel's willful assertions to the contrary of what the witnesses are telling us in terms of when they were retained. How can that be? How can that possibly be swept under the rug? The jury should be told all of this.
Tell me about the LA Times information about Lenore Walker.
That's an article in the LA Times today, I understand. Or yes, was it yesterday or today? I have it upstairs. I believe it's in the Sunday Times, Your Honor. And if the court would like, I can have it brought down.
I'd like to see it.
I will.
But before we, Mr. Cochran, you indicated a desire to address that specific issue. I'd be curious to know.
I think I read the article and what it indicated. First of all, it said, if I recall, Dr. Lenore Walker had known me since the time I was assistant DA and worked in this office, in the DA's office, that she and Geraldine Butt-Stady worked on cases that I'd had the battered woman syndrome as a defense in other murder cases. I think it also indicated that she was contacted, I believe, in December, but she was not retained or brought forward in this case, Your Honor, until after you ruled on the domestic discord. It didn't make any sense. We didn't need her until that point. We don't have a report. The court checks Your Honor's records when we made an application for Lenore Walker to go into the jail to see Mr. Simpson, along with Geraldine Butt-Stady, who saw him, it was not even concluded, saw him as late as this past Friday. The court will know the time she went to see him. We don't have a report, and she came about. She's only relevant, Your Honor, after you ruled in the domestic discord. I've known her for some time, but she was not relevant in this case until that time. So I think that I'm more than happy. She was probably talked to. I called her the first time in the fall, but she didn't get involved in the case until after the domestic discord. And I knew her since the 80s.
All right. Ms. Clark, let me ask your staff to bring down the LA Times article, although obviously that source is hearsay.
From the witness's mouth, Your Honor. Let me also indicate that with respect to Mary Ann Gerches, in her statement to us, taken most recently after counsel's opening statement, she indicates that she turned over her day runner, that's a daily calendar.
I know what a day runner is.
Okay. And that has never been turned over to us. In fact, it was never even mentioned that they had it. She indicates that she turned it over to them, and they have never turned it over.
All right. Well, I can see this is going to be an ongoing procedure here. Ms. Clark, however, I think my suggestion that after the defense has had the opportunity to comply with the court's order regarding expert witnesses, we can revisit the matter again, and I can still re-instruct the jury at any time during the course of these proceedings regarding discovery violations.
The problem is that in our proffer to reopen, we would like to include those expert witnesses.
All right. Well, when I hear the proffer, I'll rule on it. But my inclination this morning is to go forward with the jury, have Mr. Cochran complete his opening statements, then I'll hear your proffer, and we'll see where we are. All right?
Can we at least have the defense give us the names of the witnesses they intend to call as to the matters I described, the tire tracks, the shoe prints, the finger cut, the rheumatoid arthritis, those matters?
All right. That seems to me to be a clear intent to call those persons as witnesses, so I think their identity needs to be disclosed, or should have previously been disclosed. Mr. Cochran? I agree that her request is well taken.
Sure, Your Honor. I'll prepare that.
All right, well, we'll have to take a 20-minute break just to bring the jury down in any event, so you and Mr. Douglas can accomplish that in that 20 minutes. All right. I'm sorry? Certainly.
Cora Fishman.
And Mr. Darden, when do you anticipate Ms. Fishman's will be necessary?
February 9th.
All right, are you Cora Fishman? All right, good morning, Ms. Fishman. I'm going to order you to return to this courtroom on Thursday, February the 9th at 9 a.m. without further order, notice, or subpoena. Do you understand the order, ma'am?
Yes.
All right. Counsel, your appearance for the record.
Yes. Andrew Rubin, I'm here representing Mr. Machine.
Good morning, counsel. Good to see you again.
Good to see you, Your Honor.
All right. Thank you, counsel.
Thank you.
One of his clients named a cat after me. All right. Ms. Clark.
Did you, please, the court indicated one recess, I would like to hear the names.
Mr. Cochran indicated he and Mr. Douglas were going to prepare a list for you in the 20 minutes that it takes to bring the jury down. All right. Let's have the jury, Deputy McNair. Thank you. Mr. Douglas, you had something you wanted to say before we start?
I would, Your Honor. Thank you very much. Your Honor, in addition to the comments and to the objections that we lodged with the court in chambers, I would like to add one more point that was just brought to our attention recently. And that is, Your Honor, our review of Section 1054.5B does not specifically authorize a judge to instruct the jury that a discovery violation by defense counsel, for example, may be considered by the jury bearing on the credibility of witnesses. And I think that there is the danger that the language of the proposed instruction by the court gives such a suggestion. Nor does case law, Your Honor, authorize such a jury instruction. Indeed, we submit that it would be completely irrational to make a connection between a lawyer's discovery obligations and the credibility of an independent witness. I think, Your Honor, that there is a danger by such a nexus triggering profound state and federal violations, both due process and of a Sixth Amendment nature, and I would urge the court to strike that connection in the court's ruling. Secondarily, Your Honor, I respect, though I respectfully disagree, with the court's finding that the violation to turn over the witness statements of Ms. Gertjes was intentional. I suggest that before the court can properly make such a ruling, that is, that there was an intentional violation to gain tactical advantage, that the court should most properly consider that aspect within the context of a sworn declaration, that I would like to have the opportunity to submit myself to this court so that the court could then have facts upon which the court might make such a finding if the court is ruling that a violation is being imposed and a sanction is being imposed based on the court's belief that there was an intentional violation rather than an inadvertent accident, as we contend.
All right, Mr. Douglas, I'll give you leave to file whatever affidavit you wish. However, the court's ruling will stand. The court's finding stands. Thank you. Ms. Clark, you're standing for a reason?
No, I submitted the article to the court
Yes.
of Dr. Walker. I've also been informed by several people that she was on. I've been informed by several people that she was on Good Morning America this morning, indicating that she had had some 40 hours of interviews with Mr. Simpson. In light of the fact that Mr. Simpson is in court most of the day, every day, that would preclude her physical capability of having amassed that number of hours unless she had been retained quite a long time ago. And all of this flies in the face of counsel's direct assertions to the court that she had recently been retained. It's now been exposed to be an absolute falsehood. And I think that the article as well in the LA Times makes that clear also, that she was actually contacted through Geraldine Stolle in the summer, which makes it physically possible to have amassed that number of hours. So I think that what the court has before it is further impeachment of defense counsel's most recent assertions, even, of having been recently retained.
Ms. Clark, I have before me a photocopy of a press release that Ms. Walker released on, Dr. Walker released January the 26th, and the ending paragraph reads as follows, quote, "As we began to examine the evidence over the past 5 months, which included some 40 hours of evaluation of O.J. Simpson himself, we realized that the potential for long-term harm to battered women was present if the facts, patterns, and significance of the battering in this case were misinterpreted, distorted, or otherwise misused by either side. So the fact that they've been examining the evidence for the past 5 months, I think, supports your position that, in fact, there was a relationship prior to just last week. However, having said that, the defense was not in a posture to know whether or not testimony by Dr. Walker would be relevant until the court ruled on the domestic violence issues, at which point the court, having allowed testimony of some incidents and having excluded testimony as to others, then clearly set the issue before the jury. So I accept Mr. Cochran's representation that he did not formally make a determination whether or not to call Dr. Walker until after the court's ruling on domestic violence. But that also causes me to believe that if there's been 5 months of preparation, that there ought to be some notes around.
Exactly, Your Honor. Not only that,
But as I indicated to you, we'll take up the issue of experts after you've had the opportunity to look at the list that was given to you in chambers this morning by counsel.
as I recall Mr. Cochran's representations to the court when last week confronted this issue, my understanding was, and I'm sure the transcript will allay any questions we have about this, will resolve those questions. I believe the representation made was that she had not been contacted until earlier
Well,
that
counsel,
week.
We'll go back and look at this again. We've argued it enough, I think. The record's clear what's there. I'll have my staff go back through the transcript and see what's there. But I think my observation as to what occurred here is probably accurate.
The court was not left with the impression by Mr. Cochran that he had just recently contacted her?
No, I'm saying I accept Mr. Cochran's explanation that a formal decision to call her as a witness was not made until after the court ruled on the domestic violence issue. I accept that as being a reasonable explanation here. All right, but the issue whether or not there ought to be some reports back there, I don't know. But it's an issue that we'll address later, as I indicated to you. Thank you.
Okay, but while you're addressing that, would you also address the fact that Dr. Walker could not get into the jail without your orders? She never saw Mr. Simpson, so you did the orders.
Mr. Cochran, I'm aware of all those things as well.
And the orders were like in December and afterwards, and so you know when she saw him. She saw him during when he was not in court.
Seems to me you're ahead, Mr. Cochran, on this
And,
one.
so I want you to look at that. Thank you.
Okay. All right. In chambers, the record should reflect that counsel did suggest to me that I include in my admonition to the jury, my instruction to the jury, some language to the effect that the failure of the defense attorneys to comply with the law of discovery is not evidence of the defendant's guilt and should not be considered as such. I think that is a good suggestion, and I will include that in the instruction to the jury because that is, in fact, the state of the law. All right, Deputy McNair, let's have the jurors, please.
Did you hear the jury decision about the censorship prosecution of the court of the prosecution?
I made a decision. Yes, I did. I indicated I would not do that. All right, good morning, ladies and gentlemen. Everybody seems to be smiling today. Good. All right, ladies and gentlemen of the jury, I need to advise you of certain things. First of all, one of the attorneys has fallen ill, Mr. Hodgman, and he is not with us today. However, the parties have elected to proceed in his absence. Also, I need to instruct you and to explain to you some of the reasons for the delay that we have had over the past 2 days. Ladies and gentlemen of the jury, the laws governing criminal procedure in California require that each side disclose and give to the other side the names of the persons they intend to present as witnesses and any written record or recording of the statements made by these witnesses. The law also requires the disclosure of any real or tangible evidence. These disclosures must be made before trial if the witnesses or evidence are then known. These laws exist to promote the ascertainment of truth in trials, to save court time, and to avoid the necessity for frequent interruptions and postponements. During the course of the opening statements, Defense counsel mentioned witnesses who had not previously been disclosed to the prosecution or whose written statements were not given to the prosecution before trial as required by law. This was a violation of the law and one of the causes of the 2-day delay, including the absence of Mr. Hodgman. Keeping in mind that statements by the lawyers are not evidence, you are directed to disregard the comments of defense counsel during his opening statement as they pertain to the following potential witnesses: Mary Ann Gerchis, Michelle Abduram, Mark Partridge, Howard Weitzman, Skip Taft, Christian Reichard. If and when these witnesses are presented to you during this trial, you may consider the effect of this delay in disclosure, if any, upon the credibility of the witnesses involved and give to it the weight to which you feel it is entitled. Please note, however, and this is important, please note that the failure of the defendant's attorneys to comply with the law is not evidence of the defendant's guilt and should not be considered as such by you. All right, ladies and gentlemen, we will now conclude the defense opening statement. Mr. Cochran, do you wish to conclude your remarks?
Yes, I do. Thank you very kindly, Judge.
All right.
Vito, colleagues from the defense, colleagues from the prosecution. Good morning again, ladies and gentlemen. This morning again, I'll be assisted by Mr. Carl Douglas with regard to some graphics that we have, and by Mr. Howard Harris here also with regard to the graphics. As you recall from our discussion last week, in discussing the evidence, we've talked about the coroner's office and talked about what we expect the evidence to show regarding their shortfallings. We've sought to reply to the things that have been brought up by the two prosecutors in their opening statements. And I believe that at the end of the day, we'd reached the point where I told you we were about to discuss the Los Angeles Police Department and their handling of this matter. I think the evidence will show that the Los Angeles Police Department was the main investigating agency in this particular case. The two main detectives are Detective Philip Van Adder and Detective Tom Lang. They're from the Robbery Homicide Division, and they were assigned this case in the early morning hours of June 13th, 1994. In the course of our discussion today, we will be talking about the evidence which was seized or collected at the scene of Bundy and also at Rockingham. Here we have the first graphic now. Under this scenario, we expect to be talking about the integrity of the evidence. That is, whether or not this evidence is capable of your belief, whether or not it's evidence that is correct and appropriate. How was it collected? And so, for the graphic there, all the evidence picked up at the Nicole Brown Simpson condo at the top, the evidence picked up at the Simpson home on Rockingham, the evidence from the Bronco, any blood, all went first through the LAPD there. And then ultimately from LAPD, it was sent out to the various labs, be it the FBI, Cellmark, or the Department of Justice. This graphic seeks to put this in perspective. You can see the LAPD then remains a focal point in their collection of all the evidence that you're going to be required to look at. We expect the evidence will show that this evidence that was collected at these various locations that you've just seen was contaminated, compromised, and ultimately corrupted. In the course of the evidence, we expect to show that. Next. Now, briefly last week, I spoke to you about a detective named Mark Furman. Mr. Furman and his partner, Mr. Phillips, worked West Los Angeles homicide. And they are the two detectives who first were assigned to this case before robbery homicide got involved. Robbery homicide is downtown, I think the evidence will show. These two detectives worked in West Los Angeles where these crimes had occurred. and they were the first ones to arrive at the scene. Although you didn't hear about Mr. Furman in the course of the opening statement of the prosecution, we think he'll be a key witness in this case. Let me tell you why I think he'll be a key witness. I believe the evidence will show that he and his partner, Detective Phillips, arrived at that scene sometime after 2 o'clock in the morning. The evidence will show these bodies were found somewhere around 12:15 on June 13th, 1994. That after arriving at the scene, Mr. Furman did a number of things. You saw him in one of the pictures last week where he was pointing down at allegedly the glove and the cap that was under some shrubbery, if you recall. That was a picture of Mr. Furman at that point. You notice that his shoes were not covered, that he'd walked in that location at that point without shoes being covered, that he made a number of discoveries at that particular point, that there was a photographer at some time at that scene at the Bundy location, that this photographer was then summoned along with Phillips, his partner, and Van Adder and Lang to go over to the Rockingham address. We expect the evidence will be that presumably they were going over there to give notice to Mr. Simpson about the death of his ex-wife, and presumably that the children were in police custody at that point. Apparently the parents were not notified of either Mrs. Nicole Brown Simpson or the Goldmans at this point, but they went over to O.J. Simpson's residence. Now, you recall also I told you last week that Detective Furman had previously had contact with the Simpsons. He had responded to the so-called 1985 incident. He didn't write a report at that time, but in 1989, he wrote a written report. In that report, he talks about the incident of the 85 incident being indelibly impressed upon his mind. So he had contact, had been to the Rockingham location. Now, the evidence, I think, will show that he will allege that the reason why he was still leading Detective Van Adder and Lang over to the Rockingham address is because he knew where it was. But I think the evidence will also show from Detective Van Adder that he, too, had also worked in West Los Angeles, and he knew the way over there. But at any rate, I think you'll find that the evidence will show that all four of these detectives, this is prior, of course, to the coroner ever being notified, leave the Bundy crime scene, and they go over to Rockingham. Once at Rockingham, Detective Furman, of course, now by this time, the case is now in the hands of the capable individuals from downtown robbery homicide. He continues to play an integral part in this case. I think the evidence will show that he, in looking at the Bronco, now it's still, by all accounts, I think, still dark outside, but he's looking at the Bronco. It's now maybe getting close to 5 o'clock in the morning, maybe the light's about up. He discovers what he believes is a speck of blood on the door. This is Detective Furman. He discovers some more blood allegedly down toward the bottom of the door. That at some point, when these officers can't rouse anybody at the location, Detective Furman is the one who climbs over the wall to go into the premises. That once in the premises, he's the one who interrogates Mr. Cato Kalin. That he's the one who also, after talking to Mr. Kalin, goes back and finds this glove, the alleged right glove, at Rockingham. We have now for you some video relating to Detective Mark Furman, and I'd like for you to listen to what he has to say with regard to the glove. Now, in fairness to Detective Furman, the question he's been asked is about the glove, and they talk about the glove. But in his responses, you'll see, he at some point talks about seeing them at the foot of Mr. Goldman. Mr. Harriser?
How far would you say you were from where the bodies were located?
I was directly above the female victim, which was probably 3 feet. The male victim would have been 10 feet, 12 feet.
All right. And from that vantage point, you first observed the glove that you told us about?
Not first, no.
When did you first observe it?
We had flashlights. We we're looking at the female victim. We looked at the male victim. I noticed the glove when I walked around to the, after I exited the residence the first time, I walked around to the side, or the north side, north perimeter of the 875 Bundy. There's a iron fence, and through that iron fence you can get very close to the male victim. And looking there, I could see them down at his feet.
You recall, and you heard the testimony that I could see them down at his feet. And the question we'll be seeking to establish in this trial is when he said he saw them down at the feet, was he talking about two gloves at that point? Now, also, this detective plays a critical role as he remains at the Rockingham location. You recall last week I mentioned that we expect to call a witness by the name of Rosa Lopez at some place in the case. Rosa Lopez lives next door to Mr. Simpson. She is a lady who's employed by the family there. She is their housekeeper. And there will, we believe, be testimony that Detective Furman had a conversation with Rosa Lopez on the early morning hours after about 7:30, 8 o'clock in the morning on June 13th, 1994. And at that time, Rosa Lopez shared with him her observations that she had been outside the night before and that the Bronco vehicle parked there at the curb at Rockingham was parked there at approximately 8:15, 8:30. It was parked at a kind of a unique angle. And she had reason to remember that as she went outside to walk her dog. She will also testify that she came back outside to walk that same dog at about 10:20 p.m. She saw the Bronco parked in that same location that had not been moved. That the next morning, when Detective Furman had spoken with her, the Bronco was still parked at that same angle, as though it has not been moved all night. She will share with you what, if anything, she said to the detective that morning. You will find out whether or not he reduced any of this conversation to a report, whether or not that report was ever forwarded to anybody, whether he told any of the detectives about it. We expect that she also indicated to Detective Furman that when Mr. Simpson left his residence somewhere around 9 o'clock, and there'll be testimony that he and Mr. Cato Kalin went to get the McDonald's hamburger, that she was aware and heard his voice when he left, that she heard what she believed to be prowlers during this period of time and became quite frightened. We expect she'll also testify that she heard Mr. Simpson's voice at around 11 o'clock or a little after that. And when she heard his voice at 11 o'clock, it appeared as though he was leaving. And she did not hear his voice anymore that particular night. That after Mr. Simpson's voice was no longer heard, after he presumably had left the Rockingham residence, that she heard men's voices beginning at about 12 o'clock, lasting until about 3 o'clock in the morning. She was not able really to fall asleep until perhaps 4 o'clock that morning, and was awakened because I think the gardener came that morning, and she also had this conversation with Detective Furman, who came and showed his badge and then came inside of her house. So we think that, in truth and fact, Detective Mark Furman will play a very, very critical role in this case regarding his testimony. Now, let's go back, if we're going to talk about the LAPD, and let's look at the statements regarding the coroner. You'll recall last week I indicated to you that the coroner's office for some reason wasn't called initially. They arrived at the scene almost 10 hours after these bodies had been discovered. Let's look for a moment using the Elmo with Mr. Harris as at the sequence of what took place, and for the record, I'll read certain things into the record from the transcript, Your Honor. Is that as clear as it's going to be? The underlined portions I will read for the record. This purports to be, and we will establish at the time of trial, this is a conversation that took place on June 13th, 1994, at about 6:49 in the morning, just before 7 o'clock. And it's a telephonic communication between the deputy coroner, Paul Willis, and Detective Phillips of the LAPD, Phillips being Furman's partner. Detective Phillips, I got a double homicide that we want to let you know about. It's going to be, the press is going to be crawling on us like ants when they find out what's going on. Detective Phillips, This is the first call, and we got a lot of work to do yet. But we need to get you guys rolling out here so we can get these bodies, which are visible from the street, out here as soon as possible. If I can digress for just a moment, you recall that he's saying this is the first call from Phillips to the coroner's office at 6:49 for bodies that were discovered by the police at 12:15 a.m. He also says something else that I think the evidence will show is very interesting. When he says that we're going to get you rolling out here for these bodies which are visible from the street. You'll recall that when I spoke to you last week about Ellen Aronson and Dan Mandel walking past this location at 10:25, not hearing anything, not seeing anything on the sidewalk directly in front of 875. And you have seen the other photographs of what you could see from that sidewalk, and it's clear from his statement you could see these bodies, and of course there was all the blood with the scene. Continuing on, we kind of not following procedure, but we're kind of asking a favor, and kind of work a little bit on this one. So we have the detective saying at this point they're not following their own procedures, and they're asking the coroner's office to do them a favor and cooperate with them. Thank you, sir. We'll go to the next page, page 240 for the record. This Detective Phillips again, still talking to the deputy coroner, Mr. Willis. Detective Phillips. Well, you can see them, from the street here. They're a little off the sidewalk here in front of the house. But the problem is, when this thing breaks, we're going to have news from everywhere here. It's going to be a high-profile type deal. It's the ex-wife of a very prominent sports cast star or sports celebrity. Then he's asked a little bit above, he says, okay, I'm going to have to trust you on this. It's O.J. Simpson's ex-wife. That's Phillips telling the coroner again. And he goes on to say, the coroner says, oh boy, okay, and Phillips says, and he's in Chicago, and Willis says, he does not know anything about this, and Phillips says, he knows now, and that's what's going to break this thing wide open. Next page, page 241, Mr. Harris, sir. Now, Mr. Willis hears this, and I think the evidence will show he's the coroner. He wants to get rolling. And on this page, in page 241, here's what Willis says. Okay, you want us rolling out now. And then Detective Phillips says, hold on a second. Tom, and I think the evidence will show when he says Tom, he's talking about Detective Tom Lang. So you're not confused, there's two Tom Langs in this case. It's the Tom Lang who sees Mr. Nicole Brown Simpson out on the sidewalk, and he sees the Mexican gentleman behind her at 10 o'clock, and there's Detective Tom Lang, who is Detective Van Adder's partner. So he says, hold on a second, Tom, you want the coroner now? No, hold on a second. How long? Okay, you're just getting the first call. And then Phillips goes on to say, we'll give you a call back when we want them moved, presumably meeting the bodies, I suppose. Detective Phillips, it's probably going to be about an hour to an hour and a half. So here we have them calling more than 6 hours the very first time, at 6:49. Then when the coroner wants to roll, or says he wants to roll now, they then say maybe an hour to an hour and a half later. Move to the next page, please. All right. Phillips says, what I'm going to do is I'm going to give this to the supervisor because I'm leaving now. Phillips says, all right. Willis says, and tell them that you're going to be calling back about an hour and a half. Phillips says, okay, and again, we don't want that out. That essentially ends the first conversation. To put it in context, let's see if and when they call back. And we will present evidence to show that at about 8:08 in the morning on June 13th, 1994, there was, in fact, a second conversation between Detective Phillips and Mr. Richard Heath, then of the coroner's office. Detective Phillips says, we already gave you guys the first call several hours ago on Monday. Heath, yeah. Phillips, okay, can you give me an ETA, an estimated time of arrival, if you started rolling now? Some conversation with Phillips, with Heath rather. And Heath goes on to say, yeah, my name's Heath, H-E-A-T-H, and I could give you approximate arrival time of driving time from the main office in about maybe another 15 or 20 minutes added to that. And Phillips says, okay, so you're talking a good 45 minutes then? Detective Phillips, to an hour. Next page, sir. Detective Phillips says, you're not going to roll them for an hour? And Mr. Heath responds, no, we'll be there within 45 minutes to an hour. Now, we think that this evidence is a very important evidence because it starts right at the beginning of this investigation by the Los Angeles Police Department. First, they've already failed to notify. Then when they do notify, they've got so much work to do yet. We know that the coroner's office doesn't come out there until they don't get the final call till 8:08. And so we know then perhaps, according to this man, Mr. Heath, it's at least 1 hour or so after that before they even get out to the scene. You've heard me mention Detective Van Adder, who is the detective in charge of this scene, a very experienced detective from robbery homicide. And as with all of the witnesses in this case, their credibility will be questioned, and we'll be looking very closely at their credibility and what they did that night and how they conducted themselves. We must do that also with Detective Van Adder. Detective Van Adder, on this particular morning at about 10:45, sought a search warrant. As the evidence will show, Mr. Simpson was not in Los Angeles, he's in Chicago. The detectives had gone over the wall first, but thereafter they sought a search warrant. That's not relevant, but what is relevant is the credibility of the detective and what he said to the judge in seeking to get this search warrant. Mr. Harris? And what is the number? We should be giving numbers.
That is D40.
All right. You'll see in this number.
D41.
This is D41. It's a search warrant and affidavit, and you'll see it signed by Philip L. Van Adder on June 13th, 1994, at 10:45 in the morning now. And this is after they've gone over the wall, et cetera, and this is an application to a judge to try and go into the house and search. A sworn affidavit. All right?
42.
All right. And this one, Mr. Harris?
43A.
All right, you pull that up.
And D43B.
Now, here's what the detective in a sworn affidavit says to the judge to get this warrant. It was determined Simpson had left on an unexpected flight to Chicago during the early morning hours of June 13th, 1994. Now, we will introduce evidence to show that that was a direct misrepresentation and untruth, that the police knew from Cato Kalin, the conversation with Arnell Simpson, that Mr. Simpson had been on a long planned trip to Chicago.
D44.
And
D45.
he indicates that himself, that by interviews of Simpson's daughter, and that would be Arnell, and a friend, Brian Kalin, he writes that in. That's what's in the writing to the judge to verify the fact that O.J. Simpson is like gone on this unexpected trip, like run away to Chicago. And he uses that as a reason in talking to the judge.
D46A.
The next thing I'd like to show you is that is the statement from Brian Gerard Cato Kalin. What's that number, sir?
D46B.
Now, thank you. This statement from Brian Gerard Kalin, you notice this statement was taken by the police on June 13th, 1994 at 6 o'clock in the morning. Remember I told you that Detective Furman went into his room and talked to this man in the early morning hours. And Simpson, the statement is, Simpson told him he was going to Chicago for Hertz Corporation. So they knew why he was going to Chicago. They knew it was not an unexpected trip. So this was a lie when they were talking to the judge at that point.
D49. D50.
The next issue of credibility deals with the detectives indicated to the judge who they were seeking the search warrant. They observed what appeared to be human blood, later confirmed by scientific investigation personnel to be human blood on the driver's handle of the vehicle. Well, the evidence will show that they may have confirmed it at some point much, much later, if ever, but they had not confirmed it at 10:45. It was not human blood. They could not confirm human blood. So that was another misstatement to the judge at that particular point. Now, in addition to that, and I'll read these for you, the other inaccuracies of some importance that we think the evidence will show are as follows. The detectives, in seeking this particular warrant, never disclosed to the judge the manner in which entry was made. That is, they'd already climbed over the wall. They never bothered telling the judge that. And then finally, the final inaccuracy that I think you will find of some great relevance, the fact that Mr. Simpson had in fact been contacted by Detective Phillips and had volunteered to come home, taking away from the warrant any implication that he had somehow fled the scene. That was never done. Now again, this is the evidence from their files, and based upon what their lead investigator said to a judge. And at some point in our opening statement today, I want to characterize for you how Mr. Simpson conducted himself in the early morning hours of June 13th with the way that the detectives conducted themselves. This brings us then to a discussion of the Bundy crime scene. You recall briefly the other day I talked to you about, we think the evidence will show ultimately this was a place of the gathering of the evidence. And that we think the evidence will show that it is very important at the crime scene to secure this area. That people should not be walking through the evidence, should not be tracking up the evidence, should not be touching things without gloves, should be in some way protected, because this evidence is all very, very sensitive. We would expect that hopefully by the time of trial, you will actually have some footage from local televisions of how the detectives and how many people were out there, and whether or not they were, in fact, wearing anything over their shoes. You've already seen in the prosecution's opening statement Detective Furman's shoes and how they existed at the time. We think the evidence will show that this scene was tracked and traipsed up, and the gathering of evidence was a complete disaster. And we feel that the evidence will be shown to be contaminated, compromised, and corrupted, as we've indicated earlier. Now, Your Honor, before we show this next graphic, I want to say a word to counsel, and you may want to use your switch.
I've already. All right, I'm going to direct photographers not to attempt to take photography of the screen in the courtroom.
I've spoken, so the family of Mr. Goldman will be aware with regard to this picture. This is the only picture that in any way could cause any concern, Your Honor, but we'd like to move on at this point. Now, this purports to be a photograph of Mr. Goldman's body while still at the scene of the Bundy location. And you will notice several things about this particular photograph. I believe the evidence will show, first of all, that the lady whose shoes are there, these shoes are uncovered. She's standing on some kind of a white sheet or something of that nature. You can see blood on this photograph. She has nothing over her shoes. She's standing there. You see the body. And you'll see something else interesting. You'll see some gloves. Now, these gloves have blood on them. And these gloves have now been dropped on Mr. Goldman's body. Now, these gloves are, the evidence will show, are typical of the kind of gloves that are used at the scene to pick up evidence or to collect various and sundry things. And yet you see these gloves now found on Mr. Goldman's body in this fashion. And we think this is typical of the way things were conducted at that particular location at that time.
Sorry, that was D60.
Thank you.
Thank you, Mr. Judge. We expect, as we indicated last week, to show that based at this particular crime scene at Bundy, there'll be a number of things that we expect the evidence to show. That one of which is this crime scene and the patterns of the crime scene are consistent with a major struggle. that Mr. Ron Goldman's blood, as I told you, should be all over the perpetrator, especially in the upper and middle parts of the perpetrator's body. You'll recall that Detective Furman's description this morning, where he described this rather small area where Mr. Goldman's body was found. You recall he talked about a fence, and you've seen, I think, some pictures. You'll see a tree in the area. It's a very small area. In fact, he had to go outside to look outside the fence to see where the body was. A very small area. And I think that you'll find if there was this major confrontation, and you recall last week Mr. Goldman's hand that I indicated to you, I expect there'll be testimony that that hand came in blunt force trauma with one of his perpetrators or one of the perpetrators there. And there would be some marks and some injuries, it would seem. Plus, there are trees, there's this fence, and there was a violent struggle. So that if you recall the pictures of Mr. O.J. Simpson last week, you understand that will be important evidence as to the lack of any marks, bruises, or anything of that nature. In the area, we expected the scene to also show that in the area where these murders took place, there are a number of footprints in a very small area, which means that most likely the perpetrator had to be there for a period of time and that there was this pattern of fighting. I think the evidence will be in this case that Mr. Goldman's blood is on different areas of the location, which means that he too was moving around. So there was this kind of a confrontation or this fight that went on over a period of time as one is fighting for one's life. And as you know, it was a violent struggle in which he ultimately was stabbed some 31 times. Now, the prosecutor, 30 times. The prosecutor indicated to you all this happened very fast. And I think that you'll see from the evidence that's not exactly correct, given the situation and when one is fighting valiantly for their life. There was some testimony last week about certain blood drops, I think, by the prosecutors that were at or near the many footprints. And I think that you'll find that it'll be very unusual and that it'll be a remarkable occurrence that there are only 4 drops of blood that they talk about and so many footprints. Further, we'll look very closely during the course of this trial at the glove, at both gloves. We'll look at the glove found at Rockingham, the right glove. We'll look at the glove found at Bundy. And we'll be looking to see whether or not there are any cuts on those gloves consistent with any cuts or anything on Mr. O.J. Simpson's hands. We expect that there, as I mentioned to you last week, there will be fingerprints on the railings that are fresh at Bundy. And we think that the evidence will show those fingerprints are not O.J. Simpson's fingerprints. That there are hairs on the cap and the glove at Bundy that are not O.J. Simpson's. The theory is at the crime scene, I believe you recall when the prosecutors were making their case last week, there is a triangular piece of paper shown in a photograph near Nicole Brown Simpson's head. It was never saved, apparently, by the police. We don't have that. And of course, you've already seen, and there will be a number of other photographs of people with unprotected shoes standing in and about the crime scene. There will, of course, be also photographs of criminals without proper head covering and gloves actually involved in collecting evidence. So, I hope this gives you kind of a preview of how these detectives collected evidence and how they dealt with this particular scene. A scene that would be best videotaped, so you could see everything that took place, rather than just still photographs. A scene that would be best preserved, where only people who have their real business are there. Not people just walking around and traipsing through the evidence. You hear a lot about that during the course of this trial. Next, we'll come to the Bronco. Remember, all these pieces of evidence go from the location, such as the Bundy, through LAPD to some other place. So let's now look at the Bronco, what we call the Bronco timeline. Mr. Douglas, will you put the chart up? And then Mr. Harris, I think. Mr. Harris, the number on the...
D62, and the chart has another number.
That is 206.
Thank you, Mr. Harris and Mr. Douglas. Now, You'll see in the exhibit up on the board, the large board, the video exhibit, you see a lady against the Bronco. That's the Bronco that you hear a lot about, and that's a photograph taken on June 13th, 1994. You'll see the tow truck behind the Bronco. And you see this lady up, apparently peering in the window of the Bronco. And we expect to show that this Bronco, which you heard, there's important evidence therein, was not secure, that people such as this lady graphically were allowed to walk up, touch it, that when that Bronco left that location, there'll be evidence that there were at least 2 coffee stains on the hood of the particular Bronco, that it wasn't secured, that it wasn't preserved, that it wasn't made so that you could count on that evidence. Is that it on that one? Is that it?
That is D63.
All right.
D64.
All right, now this, thank you, Mr. Harris. The Bronco was, of course, impounded. This is the 94 Ford Bronco, and this is the license number of that particular vehicle, as you can see.
D66A. D66B.
And when this Bronco was first taken away, it was taken to a place I think they'll call the print shed, check for fingerprints or whatever. And you'll see that in that form, this large form here, this is a blow-up of this area right up here in the upper left-hand corner. There's an indication of prints, evidence, give special care. This box is apparently checked at that point, and you see RHD, and I think that stands for Robbery Homicide Division. That's where the detectives came from. So they had checked this, so this would be given special care at that point, the Bronco. All right, Mr. Harris?
D68A. D68B.
All right, and there were some special instructions to take the vehicle to Print Shack, PAB, across the street of Parker Center. And then they note for us that there are 2 coffee stains on the hood, disregard not related. You will have to make the determination of whether that should be disregarded. However, because if this vehicle was properly handled, it's a question of whether or not those coffee stains would even be there. Mr. Harris?
D69. D70.
All right.
D71.
After the Bronco had been to the print shed, it was then removed and taken to the impound at a place called Vertels, Viertels, the towing yard here in Los Angeles. And you'll see it's impound, and you'll see the 94 Ford Bronco again, and again the license number. Mr. Harris?
D72 and D73.
Well, let's see. When they got this Bronco at Vertels, let's see if they used this same form. The robbery homicide, RHD there you see. And you see that the check where the prints or evidence or give special care is no longer checked. There's nothing there. Nothing in that location.
D74 and D75.
This will tell you what instructions were given regarding that Bronco as early as June 14th, 1994. I think the evidence will show. The instructions were hold until released to rep from Hertz Corporation. And I think there'll be evidence this vehicle was actually owned by the Hertz Corporation. So you'll notice that no special precautions were taken. This vehicle was being held for release to the representative from the Hertz Corporation at that point. Of course, then now we're back to this question then of the integrity of the evidence, and you have the Bronco there going through LAPD, than anything out of the Bronco. Now I'd like to walk over, with the court's permission, to move closer without blocking anyone, with the so-called Bronco timeline. May I proceed, Your Honor? Thank you very kindly. This is the so-called Bronco timeline, and let's see if we can put this in perspective for you. There'll be testimony that the LAPD announces that the Rockingham site was quote-unquote secured. And there'll be a major question regarding that. That's in June. We know that there was the initial search of the Bronco for blood and trace evidence on June 14th. Then, within a day thereafter, on June 15th, 1994, the vehicle was towed to Vertel's. And that's the towing yard I just spoke to you about. And that's the place where there was the only indication was hold for release to the Hertz Corporation. And so you can see in June what took place. Now, we know and we expect there will be testimony that as early as June 15th, the day that vehicle, the Bronco, was towed to Vertel's, there were documents taken out of the driver's side pouch. We expect there will be testimony from a man by the name of John Meraz, M-E-R-A-Z. Mr. Meraz will indicate that they all knew down there this was O.J. Simpson's vehicle, that he got inside that vehicle. And getting inside, he took some receipts or invoices. And I think the evidence will be that some of these receipts or invoices were made out or in the name of Nicole Brown Simpson. So I think you'll find in the course of the evidence, Nicole Brown Simpson also drove that vehicle. There'll be further evidence that she was in the vehicle, perhaps had gone to the cleaners or some place to pick up some item. But Mr. Meraz will tell you that he took these items out of the driver's side pouch on or about June 15th, 1994. He will say that he put those items back in to the Bronco. But the items were then subsequently stolen or taken in another burglary of this particular car that's supposedly secure on Vertel's property. The upshot of it is that today, 7 months plus later, we don't have any of those receipts. They've been stolen, they've been taken, they're gone from this supposed secure vehicle in custody of the police or in Vertel's. And so this Bronco timeline seeks to spell that out for you. You'll note in going back that we have a smaller picture of the woman touching the Bronco. That's still while it's at the scene. You know what's happened on the 14th, then the 15th, and we move on. Mr. Meraz takes the documents initially on the 15th, and I think he says he puts them back almost immediately, within a short period of time. They're kind of like souvenirs, I suppose, if you believe what he tells you. But Vertel's does not report the removal of the documents to the police and the police commission until July 11th, 1994, almost a month later. The official word came out that these documents have been taken and they're missing. And of course, they then start an investigation to try to find out where these documents are. This Brown timeline talks about this whole period of time when we think the evidence will show that the Bronco was improperly stored without the appropriate holds, and then when it was improperly stored, that some bad and unfortunate things happened with evidence having been lost. Now, you'll see, between this period of June 15th, that's the date that the Rots got inside when it was brought to Vertel's, and August 26th, did not observe special care rule to preserve the integrity of biological and trace evidence. We think there will be testimony that this vehicle, it's possible this vehicle for any number of people to get in and out of that vehicle, and there was not the hole on it that it had in the print shack. Then, lo and behold, on August 26th, between the period of August 26, 1994, and September 1st, 1994, there was, done by the prosecution, an extensive search of the Bronco for biological and trace evidence. They went back looking for evidence used in this trial. Now you can see this is for a vehicle that had been towed there on June 15th. So what is that? 2 months plus, almost 2.5 months. Go back. Now they're looking for extensive search for biological and trace evidence. This is a vehicle that we know has been basically improperly stored. There's been at least one burglary or trespass, and maybe two if Mr. Meraz is believed. Yet then they then go back and seek to get evidence out of there. And this goes into what I've tried to describe for you of the graphic there, of the integrity of the evidence, what happens to that evidence, where it goes before it gets to you, and who has had an opportunity to contaminate it or compromise it or in any way corrupt it. That leads us to the point of this integrity of evidence being contaminated, compromised, and corrupted. And we think that the saga of the Bronco illustrates this concept of the evidence being contaminated, compromised, and corrupted. Thank you. Well, now, with your permission, turn our attention now to this whole concept of a discussion of DNA evidence in the Los Angeles Police Department. I suppose that there's a saying that if you have garbage in, you get garbage out. And we have several charts that we think will be illustrative of this whole concept of DNA evidence and what it actually means. Mr. Douglas is placing a chart on the board. And Mr. Harris, do you have a laser? The black box? You did it. You did the black box already. And we put the black box up because, again, this deals also with the integrity of the evidence. Now, with regard to this particular exhibit, before I get to that, Ms. Clark, I want to make a few statements, and I'll let you know when we get to that. All right. Nowhere, I think, will you find in this case is the problem of the evidence being contaminated, compromised, and corrupted more important than the area of DNA testing. This is the evidence will show is a very new and powerful technology. In the past 5 years, police departments and crime labs have tried to transfer this DNA test that has been used for research and medical diagnosis and apply it to crime scene samples. We expect, though, you will hear in the course of the evidence, this transfer of technology has not been simple or easy. And so I want to share with you in the course of my opening statement now some differences between DNA testing for medical purposes and forensic DNA testing on crime scene samples. Remembering in the graphic, that all evidence passes through first the LAPD's hands. If it's compromised when it starts, it's compromised when it comes out. If the evidence was contaminated at the scene or mishandled by the Los Angeles Police Department, it doesn't matter what DNA tests are done afterwards, how many times they're done, or which laboratories did them. The results will not be reliable, we expect the evidence to show. Now, to understand the problem of contamination, one must understand, first of all, how small these samples are. And Mr. Douglas has gotten ahead of me just a little bit. Let's go back to small amounts of DNA. And for illustrative purposes, to illustrate this for you, this is a chart that's titled Small Amounts of DNA from Specks of Blood. Now what we have is a regular sized penny here to the far left. And I want you to be able to compromise or construct that. I want you to be able to compare the regular sized penny with 20 nanograms of DNA. And that amounts to, those of you can see very well, I'm pointing to it, almost like a pinprick. It's 20 nanograms. Much of the evidence in this case, you'll be asked to make decisions regarding, is 1/10 of that amount. 1/10 of the 20 nanograms are 2 nanograms. An amount so small that you can't even see it. That's what we're trying to demonstrate in this chart again. The penny, the 20 nanograms, 2 nanograms, an amount that you could not even see with the naked eye. So Douglas, and that exhibit I was just referring to, Your Honor, was
207, Your Honor.
now, Mr. Douglas.
This is exhibit 210, Your Honor.
Oh, I'm sorry. We think the evidence will show, and including the last chart that was just taken down, that these small, minuscule amounts of DNA are very easy to spread around. They can get on your clothes, in your hair, tweezers, scissors, other tools, be moved from one place to the other without anyone seeing or knowing what is happening. And this, of course, is how you get contamination. Now, during the course of my remarks today and then last week, and before that, the remarks of the prosecutors, we've all stood at this particular podium. If I sneezed, or if any saliva came out, or if I scratched my hair and any dandruff was there, or if I touched this and had any blood on my finger or a splinter there, if Ms. Clark did likewise, if Mr. Darden did likewise, then our DNA would be on this area. And if I took a handkerchief out and wiped this, such as they do in labs, that would pick up the various DNA that's here. You can't see it. That's how small it is under these circumstances. So that gives you an idea. If we were to wipe it across here, a handkerchief, it could now be taken to the lab and allegedly tested. In fact, some medical labs, as I said, do in fact do this, and it's done in the lab in a scene to determine whether or not there's any contamination. That's how they test it, to see if there's contamination. If you're trying to test to see if someone is going to be able to be compatible for a particular organ transplant, they check to see, because you can't see this. Now, as I gave the example, if I had been the only one here, you might expect to find only my DNA. But if Mr. Darden and Ms. Clark were here, you might expect to find their DNA. If Mr. Van Adder here sneezed, you might find his DNA. So there's all kinds of ways in which we have this possible contamination. And one of the problems with the test is that it cannot tell one person's DNA from another. This is what we call, and I think the evidence will be, a mixed sample. There's a great controversy, we think the evidence will show, about whether small mixed samples can be tested reliably, even if everything else is done properly and there is no contamination. So if you had contamination to it, then you can see what the problems are. Now, to give you a perspective, now, ready. This board that I'm now going to refer to is the so-called DNA testing technology transfer board. What we want to demonstrate here, as you recall, I said that over the course of the last 5 years, what we're trying to do here is to transfer from what we use in medical research and to exclude suspects primarily to the field, to forensics, to crime scenes, to try and make it work in that setting. This is, as I indicated to you last week, cyberspace or 21st century technology. And I think you will find the evidence will be that the collection procedures are 19th century or covered wagon collection procedures. And that's why it's such a problem. And so if you looked at this medical research area, generally you could expect that in the medical field that there are clean samples, more than likely in a clean medical lab. The blood is carefully taken under antiseptic conditions in hospitals. And in a forensic setting, DNA testing is done by definition generally. Dirty samples are taken from crime scenes, from sidewalk, from carpets. And they're exposed to all sort of contamination. That there are many different sources. These are, as you know already, these are minute specks of blood. There may be saliva, there may be skin, cells, dandruff, as I indicated to you. Even a spray of a sneeze can contaminate the forensic sample. So what I want to do in this example, we have these charts here, is this. In comparing the medical research, we're going to compare the medical research with the forensic and see which one is more likely to be reliable under the circumstances. Well, I think that the evidence will show that as opposed to the clean samples and the dirty samples, in this instance, the clean sample in the medical lab will be far more reliable, something reliable. The next area we'll be talking about is generally in a medical lab, you have a general sample size. The doctor can have whatever sample size he usually wants or needs. In forensics, the samples come generally in very, very limited, minute amounts. When working with such small amounts, often the test can only be done once. And of course, we think the evidence will show that it's harder to produce reliable results under those circumstances. In fact, you will hear, we think in this case, that most of the important DNA tests performed by the prosecution were done with amounts of DNA that were actually below the preferred amounts for reliable testing. So if you talk about the medical research labs having a general sample size, and in the forensics area having minuscule sample size, again, you can see there is a higher risk of contamination in the minuscule sample size. And that brings us down to the unmixed samples from known sources. As you know, and Ms. Clark alluded to this in her statement, in a medical setting, you have people that you know. If you have a lady who's going to have amniocentesis, you know who that is. You have someone who's going to give, one person's going to give somebody else a kidney, you know who they are. So you have known sources that you're dealing with. And that makes a big difference, as I think you'll see during the course of the testimony. In medical testing, we take these unmixed samples from known persons. In forensics, we use and collect samples that could be mixtures in varying amounts from a number of unknown people, because you don't know who's been out there, who's walked, who's sneezed, who's bled, who's scratched their head. You don't know over a period of time. We expect that you'll hear, again in this area, that the new forms of DNA testing used by the prosecution in this case are just not reliable enough to use when analyzing mixtures from unknown sources. And the key thing here being mixed samples from unknown sources. So again, once again on forensics, there's a higher risk of contamination. Then in the lab, in the medical research area, there is generally minimal handling. This is fairly clear and straightforward. There's less handling than in the scene when you have someone going out trying to collect something. Contrary, as I said, to what the prosecutor told you last week, the evidence will be it's not as simple as wiping up a spill in your kitchen. This technology is so sensitive. It's not that simple at all. You and I just shouldn't go out and do this. We can do it. We wanted to use the same techniques they're using with the LAPD, but you get results that are all unreliable. So between minimal handling and multiple handling, you can see again, there's a higher risk of contamination with the multiple handling. Error rates, better known. And that's because, I think you'll hear testimony, that in the medical labs, they subject their results and things to tests. I mentioned the wipe test. In labs, they do that because they're concerned about contamination in the labs when you go to the doctor. You want to have the doctor make sure his lab is contamination-free as near as possible. It brings about confidence, and that's what we've done a whole industry based upon. Transferring this technology to the forensics area, the error rates are not nearly as well known, as I think you can see. So again, there's a higher risk of contamination and error in this area also. I think you'll find that in the course of the testimony that the labs have a higher standard for doing DNA testing in medical laboratories. They're much stricter on themselves than the standards that forensics and the police departments and laboratories are using. And so you can see how important it is. In one case, when you're talking about these high standards, you're concerned about whether or not your organs will be compatible, if you want to have an organ transfer or whatever. And the other, concerned about somebody's freedom, their virtual life. And so we're going to see whether or not, under this scenario, whether or not there aren't higher clinical lab standards when you're concerned about somebody at the hospital than you are when somebody's on trial for their very life. And given that, lower lab standards and the lack of testing, and again in this area, in forensics, there's a higher risk of contamination and error. I mentioned this earlier, but in the labs there is this rigorous proficiency testing. And of course, I think you'll find the testimony will be that in forensics, very rarely do they do any blind testing, no outside agencies. They give themselves easy tests and almost never take blind external proficiency tests. And that has a real bearing on the overall proficiency here. And so again, I think you'll find there's a higher risk of contamination and error in the forensics area again. And then finally, with regard to statistical controversy in this area, in medical testing, usually you're just trying to see if someone has inherited a copy of the disease gene from their parent or whatever, has the correct genetic types for transplantation of an organ, or has been infected with a harmful bacteria or virus. That's what you're looking for. And there's no elaborate statistical estimates are needed to get reliable test results for that. In forensics, we think you'll hear testimony that there's a bitter and complicated statistical controversy regarding this entire area, DNA, and specifically PCR, about a DNA match and what a match means. And while we're about it, I think the evidence will show when you hear the prosecutor talking about it's a match, it's a match, it's a match. What she really means to say is that it's consistent with. These are not fingerprints, consistent with someone else's genotype or with their blood type. So with regard to this whole area of statistical controversy, again, the forensics area, the higher risk of contamination error in this area again. So if you look at this chart, you look at blood on both sides of that, you can see clearly, and I expect the evidence to be, that because of the dirty samples, the minuscule sample size, the mixed samples from unknown sources, the multiple handling, the error rates not well known, the low lab standards, the easy proficiency testing, and the major statistical controversy, and in all those areas, the seeking to transfer this technology to forensics is fraught with all kinds of problems, and there is a much higher risk of contamination and error. Now, we expect that during this hearing you will hear some astronomical numbers presented regarding the DNA test results. And these numbers are part of what I was telling you, the statistical controversy, whether or not these are accepted in the science. And these numbers also only address gene frequencies. These are not fingerprints. And the numbers that you will hear, if you hear them in this case, have nothing to do with the issue of contamination that we've been talking about. They do not have anything to do with the issue of laboratory errors. They don't have anything to do with the issue of tampering, whether the sample was tampered with. And they have nothing to do with other important DNA issues which you'll hear about in the course of this case. Specifically under the DNA testing aspect, we think that you'll hear testimony in this case about polymerase chain reaction, the so-called PCR testing. And I think you'll find out in here that the very best medical and research labs that do PCR have contamination problems. And as I mentioned to you last week, I think that you'll hear that this is an area that presents a real problem. We expect during the course of our evidence in this case to show that from their own studies, the LAPD's laboratory is a cesspool of contamination. Looking at their own records and the tests they've run, we will demonstrate for you what those records show. We expect then in this entire area, and the evidence will show that the careless, slipshod, negligent collection, handling, and processing of samples by basically poorly trained personnel from LAPD has contaminated, compromised, and corrupted the DNA evidence in this case. And Your Honor, that might be a good spot. Should we go further?
All right. Thank you, counsel. All right, ladies and gentlemen, we're going to take our recess for the noon hour. Please remember my admonition to you. Do not discuss this case amongst yourselves, form any opinions about the case. Don't allow anybody to talk to you about the case, and you are not to perform any deliberations on the case until the matter has been submitted to you after the completion of the case. And we will resume again at 1:30. All right, we'll stand in recess. Thank you, counsel.